For the first several days after the Lodge Club raid, details were scarce and the poker world spiraled into speculation. About a week later, the contents of the affidavit became public, and buried on page 4 was a single paragraph that, once you understand, unlocks the entire case. It reads, "A public complaint was filed with TABC on April 3, 2024, which referenced a 2005 opinion written by then Attorney General Greg Abbott that stated that a business that holds an on-premise alcohol beverage permit could not hold poker tournaments where real money was at risk by participants. This is the foundation of the entire case against the Lodge. It didn't start with a tip about money laundering. It did not start with a suspicious wire transfer or an IRS audit. It started with someone filing a public complaint pointing investigators to a 20-year-old legal opinion that the poker world had largely chosen to ignore." So what exactly is opinion number GA0335? It was written in 2005 in response to a question from the Honorable John W. Smith of Ector County District Court. The question was simple: can a business that holds an on-premises alcohol beverage permit legally host a poker tournament? Greg Abbott's answer was equally simple and equally devastating for the Lodge's situation. The opinion concluded that a permit holder cannot host a poker tournament in which participants risk money or anything of value for the opportunity to win a prize, and doing so violates both Section 47.04 of the Texas Penal Code and Rule 35.31 of the Alcoholic Beverage Commission. The critical point that people are missing is that this opinion was written in 2005, long before the modern Texas cardroom industry even existed. It was primarily aimed at bars hosting a poker night for prizes and that sort of thing. Nobody was thinking about 68-table membership poker clubs with full production studios and IRS oversight. But the language of the opinion is broad enough to apply to exactly that kind of operation, and the TABC knew it. Here is the deep irony at the heart of the story. The Lodge's alcohol license, one of the features that made it a premier entertainment destination, became one of its biggest legal liabilities. The Lodge had been issued a wine and malt beverage retailer's on-premise permit back in September of 2022. By September of 2024, that had been upgraded to a full mixed beverage permit, which was current and active at the time of the raid. Texas card rooms had long operated by arguing they were legal under a private club model which charged memberships, don't take rake from free pots, and claim the games happened in a private place, which is a recognized defense to gambling prosecution under Texas law. Many Texas card rooms used this exact framework for years without being touched. But GA0335 introduces a separate, independent, and legal problem that cuts straight through that defense. The moment you hold an on-premises alcohol permit, you are bound by both the Penal Code and TABC regulations, and under that dual framework, hosting real money poker is illegal. But the affidavit does not stop at the Attorney General's opinion. The TABC sent undercover agents into the Lodge before the raid, and what those agents found gave prosecutors a second, equally powerful angle of attack. The private place defense, which Texas card rooms rely on, requires that gambling genuinely occurs in a private place, accessible only to members. If the Lodge was a private club that required membership, the theory went that the games were legal. The problem occurred when TABC agent Teague walked in, and this is a direct quote from the affidavit. He continued into the club without showing proof of a membership, ID, or purchasing a membership. He stated he freely entered the gaming floor unimpeded and walked to the rear of the club where the bar was located. That single sentence is enormously consequential. If a random person can walk off the street and onto the gaming floor without showing any proof of membership, the private place defense collapses. And if the poker played is not in a private place, then it is illegal. And if it is illegal, then any money flowing through that operation, including the seat fee, the membership dues, the deposits, etc., could potentially be characterized as proceeds of an illegal enterprise, which is exactly how you get to the money laundering charges. The affidavit lists some of the most serious allegations imaginable, ranging from organized criminal activity to money laundering. Whether any of these charges ultimately stick is a question for the courts, but the reason for the charges is now clearly visible. While the legal machinery grinds forward, real people are paying the price. All of Lodge's staff members received an email from owner Jason Levin informing that they had been laid off effective immediately. Levin's email was, by all accounts, genuinely heartfelt. He wrote about the porters, the dealers, the front desk staff, the late nights, and the early mornings. He acknowledged that reopening risked another raid, more seized assets, and potentially criminal exposure, and that without any timeline on the investigation, there was simply no responsible path forward. What makes this story especially painful is that it did not have to end this way. Polk and other Texas poker operators had tried through legitimate channels to get clarity on exactly these questions. In 2023, House Bill 2345 was introduced to formally define and legalize Texas card rooms, but it went nowhere. The poker industry had built an empire on ambiguity. GA0335 was always there, sitting on the TABC's own website, available to anyone who wanted to find it. All it took was one person, one complaint, to make the dominoes fall. As of now, no charges have been formally filed against Doug Polk, Jake Abdullah, Jason Levin, or anyone else connected to the lodge. The investigation continues.